Welcome, everyone. This is the second talk event of the Bacon Immigration Law and Policy Speaker Series in this fall. Actually, there were a couple more spontaneous ones that were organized by Professor Eunice Lee. I'm one of the co-directors. My name is Lynn Marcus, and I'm one of the co-directors of the program, as is Shefali Milchar Desai and Professor Eunice Lee. Without further ado, am happy to introduce to you Ivan Espinosa Madrigal. He's the executive director of the Lawyers Committee for Civil Rights, the organization that filed the first lawsuits in the country against the Trump administration to protect sanctuary cities, to save humanitarian protections on behalf of Honduran, Salvadoran, and Liberian immigrants, and to block immigration arrests in courthouses. He has won dozens of life-changing and law-changing cases around the country on behalf of people of color and immigrants, and also advises federal and state policymakers on the legal needs of marginalized communities. And he speaks nationally on racial justice and immigration issues, often focusing on the legal needs of people who identify across intersecting lines of race, sexual orientation, gender identity, and immigration status. Now, before working at the Lawyers Committee for Civil Rights, Mr. Espinosa Madrigal was the legal director for the Center for HIV Law and Policy, where he supervised the legal team on national projects using HIV as a lens to address racial justice, criminal justice, immigration, and public health issues. Before that, he was at Lambda Legal, where he developed an initiative to address legal needs of LGBT and HIV affected people of color and low-income people. And he focused on marriage equality cases. And before that, he worked at the Mexican American Legal Defense and Education Fund, where he handled the immigration docket, immigrants' rights docket, and that included serving as counsel in a challenge to Arizona's anti-immigration law, SB 1070. And he was also a member of the legal team that successfully defended Northwest Austin Municipality Utility District No. 1 versus Holder, which was a landmark US Supreme Court voting rights case. I should also mention, he loves traveling, art, and being an immigration dork in his free time, and which isn't much. I've enjoyed having him around just a little bit this week. And he's also very generously agreed to meet with law students after the talk in person in the courtyard. And so we're just super appreciative of your time and glad to have you visiting with us today. I should have said, let me just wait 1 second and give some logistics here. If you're on Zoom, please feel free to put all the questions you have in the chat. We have first-year law student Kate O'Donnell, who has generously agreed to serve as moderator. She's going to be looking out for your questions, and she will also be posting the CLE link in a few minutes in the chat, because I know there are some lawyers interested in CLE. Any other thing I forgot?
I think if anybody has a question, when we get to the questions, I think we decided that ask a question and then I'll go up and repeat.
Yeah,
to make sure that everybody on Zoom can hear.
So if you didn't hear Kate, she said that if you ask a question and you're here in person, then Kate's going to come up and repeat your question so everyone on Zoom can hear. And Yvonne, thank you so much for being here.
Thank you. Thank you, Professor Marcus, for that very warm introduction. And thank you also for welcoming me to the law school community this week and for inviting me to join you on campus this week. It has been truly wonderful to be in your community. And it's a pleasure to be here again in community with you in this hybrid event, both on campus and on Zoom. And so I want to thank Professor Marcus for all of her leadership and for the work of her immigration law clinic which is truly distinguished in the field. And I want to give a special shout out also to the faculty members who have very generously dedicated their time to meeting with me over the course of the week. I see Professor Silverman here. I see Professor Milsarak Desai on the Zoom, as well as Professor Eunice Choi. I want to start by talking a little bit about myself and then talking a little bit about the work that LCR has been doing, particularly during the pandemic, and then concluding with some notes about student engagement in litigation and with the changes that we have seen moving from the Trump era to the Biden era. And so I'll start from a very personal note and say that I've lived in the United States since I was 9 years old. My mom, my brother, and I lived in a low-income immigrant community. As a single mother, my mom worked very long hours cleaning houses to put food on the table, but we couldn't afford many things. My family didn't have health insurance. I didn't have health insurance until my first job after college, and my family didn't have health insurance until an insurance exchange opened up in response to Obamacare. My family includes undocumented people who remain uninsured, even now, and who also live under the constant threat of deportation and removal. I didn't share a classroom with a white student until I was in 7th grade, and for many years I attended what were essentially segregated public schools serving low-income students of color. Many of my friends dropped out of school and eventually came into contact with the criminal justice system, and that was my personal introduction to the school, to prison, to deportation pipeline. And these are just a few examples of life at the intersection of race, immigration, and poverty. And when I came out in college, I added sexual orientation to this mix. My experiences growing up have fueled my passion and commitment for justice and equality. And today, as Professor Marcus was indicating, I serve as the executive director of Lawyers for Civil Rights. We are a Boston-based organization founded at the request of President Kennedy at the height of the civil rights movement to move the struggle for civil rights from the streets to the courtroom. At the very beginning of the pandemic, Lawyers for Civil Rights and our allies filed a major lawsuit to secure the humanitarian release of civil immigration detainees from the Bristol County House of Corrections in Massachusetts. For you in Arizona, I could draw a very easy analogy. Bristol County and its sheriff were the equivalent of what Sheriff Arpaio was in Maricopa County. Our Bristol County sheriff styled himself as a new type of Arpaio, but very much in that mold. And during the Trump administration, threatened to send immigrants to help build a wall, among other things. And so the analogy, I'm sure, comes close to home as I speak here in Arizona today. When we filed the lawsuit, it was in direct response to alarming reports that the detainees in that facility had no water, no soap, no sanitizer, no disinfectants, no toilet paper, no masks, and no social distancing. At the time, lawyers were just starting to file individual habeas petitions. This is in March of 2020. And those individual habeas petitions were securing the release of especially vulnerable individuals, particularly the elderly and those with underlying medical conditions that were recognized by the CDC as COVID-19 risk factors. It was incredible work, but I wasn't a huge fan of this individual approach. It seemed to me that we as lawyers were essentially picking and choosing who lives or dies, who gets to be released from overcrowded and life-threatening prison conditions, and who gets to stay there with COVID. And at Lawyers for Civil Rights, we refuse to leave people behind. So instead of individual habeas petitions, we broke ground filing the Savino case, the first coronavirus class action of its kind in the country. Some observers in the legal community thought we were foolish, too risky, some said. They thought it was going to be an uphill battle to get a judge to move on impact litigation issues that are systemic and structural in nature. They didn't want to risk a case like this losing. There's the way that colleagues in the legal community reacted to the filing of the Savino case reminded me that there are many ways to approach the law. You can approach the law from a low-hanging fruit perspective, help those who are the easiest to help, and to do it in the least controversial way. That's certainly one approach. But through our Savino class action, we secure the en masse release of detainees from a major detention facility. In our class action, people were released regardless of age or medical conditions. A facility with a capacity of over 200 people was reduced to 7 people through the course of the litigation. 7 people. Word spread quickly, and copycat cases were filed across the country, expressly seeking Savino-like relief. Ultimately, our class action, coupled with sustained community advocacy, helped to prompt the Biden-Harris administration to shut down the Bristol County facility. It was closed just a few months ago, marking one of the first times in recent memory that a major immigration facility was successfully shut down through a combination of legal, community, and political pressure. Today, no one is held at Bristol County. We shut it down. There's no doubt that without the precedent set in Savino, we would have seen many more deaths across the country in detention facilities. And our success in Savino shows that you cannot be afraid of breaking away from the mold. Just because everyone else is filing individual cases, it doesn't mean that you have to do the same thing. And you cannot be afraid of taking bold action, even against incredible odds. If the fear of losing or making bad precedent is holding you back, then you won't have an opportunity to win and make good precedent. You have to approach the law from the lens of survival. And while traditional individual habeas petitions are perfectly fine, our collective rights and our collective dignity cannot wait for picture-perfect clients to walk in the door. Our collective equality cannot wait for perfect fact patterns to walk in the door. As lawyers and as a legal community, we have to adapt. And at a time when so many impressive and successful examples of pivoting, particularly in the business world, I think it is important for us to think about how our profession pivots too. And I'm not talking just logistically, but substantively. To be sure, legal proceedings, hearings, and depositions have taken place just like I'm giving this chat via Zoom and through other platforms. But I would argue that relying on Zoom is the legal equivalent of a restaurant offering takeout for the very first time. That's not innovation. It's more of the same, just not in person. In the current landscape, businesses have shifted substantively. And at Lawyers for Civil Rights, where we also provide free legal support to small businesses, we have seen excellent examples. A candle maker now producing hand sanitizer. A t-shirt designer now producing masks. And the list goes on. And it involves much more than just offering services or products online. And it meets the needs on the ground at an essential time. But even if we just focus on the logistical dimension, we have seen the emergence of new service delivery models that we have to meaningfully replicate in the legal community. And what I have seen over and over is that as a legal community, we are stubborn. We are married to the status quo and to the way we have done things traditionally. And our default is generally to file those individual habeas petitions. It's almost as if we are afraid to offend someone, anyone, if we do things in a different way. And we have to think outside of the box. Raising novel claims, filing cases in new venues, joining forces with grassroots community groups or immigration clinics. None of it is universe ending. but sticking to traditional methods and styles of work will stifle creativity and limit the universe of judicial remedies at critical times, especially during this pandemic. The Savino case is a good example of the impact litigation work that Lawyers for Civil Rights champions. But we have been extremely nimble and flexible in many other ways, especially during the pandemic. There is a tremendous need out there in the community. And as lawyers, we have the resources, capacity, and expertise to help. To the law students, use your privilege and voice for good. The pandemic and everything that surrounds us is a calling on all of us to step up in ways that are not traditional. Don't be afraid to revisit how you operate and interact. And don't be afraid of questioning how traditional ways of operating and interacting are deeply connected to dismantling vestiges of racism and discrimination. We must challenge and change that. And we have to avoid the tendency and pressure to stay in our lane. I deeply believe that traditional structures and definitions of what our clients have to look like, what our legal practice has to feel like, is intertwined with systems that didn't work for many people and that have maintained structural inequities that have come to the surface, especially during this pandemic. And this desperately means that we have to be open to changing the way we do our business. We need to step outside of our comfort zone. And part of my trip here today to Arizona is especially a part of this. I am here to visit detention facilities, shelters, and soup kitchens in Nogales, Sonora, to see exactly what the impact of our immigration policies and immigration laws are on the ground. And it is critical for me as an immigration advocate to get that perspective on the ground that you guys have readily available here, but that I most certainly do not in Boston. It is critical for me to change the status quo of the way that my organization conducts its business. And this alone, I believe, will have a tremendous impact on accelerating more fair and equitable outcomes in the way we do our work and create our litigation opportunities. It is important to note, especially when I'm speaking here at the law school, that the Savino case was created in direct partnership with law students. Law students interviewed detainees to create the factual record. Law students conducted extensive legal research. Law students identified claims and prospective relief. Law students drafted complex legal pleadings. They actively participated in case strategy discussions from inception to settlement, contributing to the development and execution of the theory of the case at each stage of the case. So much so that the fact that we styled it as a class instead of individual habeases came from direct pressure from students who kept saying day in and day out, not a single one should remain behind bars. Free them all. And it was that spirit of freeing them all that guided every facet of the litigation. So in a nutshell, Savino was very much student-led work, informed by the perspectives and experiences of students and what they wanted to see happen on the ground. We recreated this magic after the Savino case when we helped to shut down the immigration facility in Massachusetts. And I share these examples because of how powerful active law student engagement and involvement can be in the litigation process and in policymaking as well. In closing, I want to directly address the title of this talk, which alludes to the post-Trump era, and I'm going to be candid. We have seen good progress. The Department of Justice now has friendly and accessible people who we can call on and lean on. And we have been doing so, actively working with them to favorably settle many of the cases we filed against Trump. But progress has been frustratingly slow And I'm not just talking about settlements. I'm talking about the horrifying images of Black Haitian refugees that we all saw coming from the border in Texas. Images reminiscent of hunting down slaves and rounding up animals. People were forced to live in squalid conditions under a border bridge. Let's be clear, this didn't happen under Trump, this happened under Biden. As an advocate, it reminded me of some of the lowest moments that we experienced under the Trump era, like the family separation crisis. And the bottom line is that the many exclusions and expulsions that were created by Trump have been continued by Biden. I saw this firsthand yesterday when I spent a day in Nogales, meeting immigrant families, interviewing community leaders, visiting soup kitchens and shelters. What's happening today at the border is unconscionable. Survivors of persecution and torture unable to apply for asylum. Families with infants deported with COVID. We met 2 of those families yesterday. These conditions create fertile ground for all of us in this room and in this Zoom to use the law as an instrument for social justice and social change. I want to thank Professor Marcus for inviting me here today. I want to thank the College of Law for hosting me. And I want to thank each and every one of you for your commitment to equality and justice. And I'm happy to answer questions. Thank you. Don't be shy. I sue, I don't bite. So, and thank you, Kate, for agreeing to moderate the Q&A component so that if folks are trying to reach me via Zoom, that they can reach us.
Yes, and once more, if you're up there, if you'd like to repeat, type questions into the Zoom.
Yes.
Here, last questions, I'll go up and repeat.
Friends, type questions into the Zoom. And if you are in person, Kate will shadow you so that that can be repeated. I see Professor Silverman. 1, 2, 3.
Okay. You touched on what's happening now within the Biden administration. Why do you think is it? I mean, the rhetoric we hear from Biden, particularly before during the campaign, a lot of it seemed pretty good. For instance, in immigration, and now we see that, as you indicated, he's adopted, a number of things that happened during the Trump administration. And what do you think? I mean, is this what we can expect from Biden, that we're not really going to see any real immigration reform and changes, or is it the political decision he's making because of makeup of the Senate at this point? We expect you.
Thank you, Professor Silverman. He's asking about the rhetoric of the Biden administration, adoption of Trump tactics and policies, and about the composition of the Senate. So Kate, I summarized it for you. I think that's a very fair question, and I think it is tied to the last point that you mentioned about the composition of the Senate. I think we are under a particularly vulnerable political landscape. There are still deep tensions and divisions and polarization. I was talking about this with Professor Marcus earlier this week about just how polarized the landscape is, and how we do need to build more bridges to connect us as we talk about issues of immigration and policy. I think that the White House has been particularly conservative in this arena to prevent more criticism of the administration being too liberal, too leftist, And you see it all the time. When we started posting on Lawyers for Civil Rights through our social media, some of our criticisms of the treatment of Haitians at the border, just the vitriol that you get from certain quarters about these people have no rights. These people, they were lucky to be kept under a bridge. Like, these people should be taken out and shot. I mean, the language is not just racist, it's violent. And that is a reality that we are constantly struggling with. And I think the polarization is what keeps the administration hesitant to be more aggressive in the immigration space, to not shake the tree too much, to follow incremental steps instead of dramatic reform, the fear of losing additional Senate seats, the fear of what the consequences will be in midterm elections and so forth. And so I think the political reality is very much at the heart of it. I also think the administration doesn't necessarily know what is the best path forward. We know that the entire system has to be completely recreated, that our current immigration system just doesn't work. And it doesn't work not just for humanitarian relief and protection, which is a lot of what I've been talking about, but it doesn't work for employment-based visas. It doesn't work for family-based visas. If we are seeing shortages, even in professional spaces where tech and green economy type of setups are saying we don't have the talent and we need to import that talent, our current immigration system's not allowing for that. Families that have to wait years to be reunited with siblings, parents, other relatives. It's clear that at every facet, from business and enterprise to family unity, to humanitarian relief and protection, the system is just not working for any of us. And so the idea that we just need to close the border, shut it down during the pandemic to avoid the incoming of that threat of COVID south of the border, to not be overwhelmed by requests for asylum and other humanitarian protections, it really misses the mark, because in not reforming the system, we perpetuate the inequities and the inefficiencies that exist also for more traditional economic or family purposes. And so we need to rehaul the entire system, and that rehauling is difficult. I am a little inspired, and I know that this is a terrible example to draw, but the withdrawal from Afghanistan is interesting, right? Something deeply unpopular, which even I don't support. It's like we left Afghanistan in shambles. We shouldn't be leaving these people like that. But he took that decision, even knowing that potential supporters, leftist supporters, more progressive supporters, though my team would probably say that I'm one of the more conservative people in my office, but I consider myself a relatively progressive. And if I wasn't supportive of the Biden administration's move to pull out, you could just imagine how unpopular this was. And so the fact that he made the decision to pull out, even at the cost of losing face with even liberal and progressive voters, I think shows that there may be some backbone to confront difficult bridges, but we haven't seen that in immigration yet. I wish that he took some of that leadership of just leading from his gut, even if it's hard and loses people like me, to do the reforms that need to be done in the immigration space. I wish we had that type of Afghan moment where it's, my God, what is happening to the immigration system? And it might not be what I want to see, and it might not be what a conservative person wants to see, but overhaul is needed desperately. Question over there?
Yeah, I want to thank you for coming and talking, and I thought it was really interesting how you were talking about the decision to pursue a class action case in Sabino versus continuing to go sort of with piecemeal individual habeas cases. And I was wondering, because, those of us here have taken or are taking a civil procedure and we learn about the differences between those types of cases, what the particular challenges are of pursuing class action cases, and what are some of the opportunities?
Yeah, that's a great point. And I have to say that when I was sitting in your seat taking civil procedure, it was kind of like just going over my head. And then when you actually are putting together a complaint and thinking about standing and who can sue and what are the injuries, what are the damages, and what's the venue, it really comes together much more organically. Another reason for you guys to get involved with clinics. So thinking about that, the interesting thing is that the class action, you just never know how judges are going to react to these things. We actually drew a fairly conservative judge. We drew a 1980s Reagan appointee in the District of Massachusetts, which is relatively progressive. So he's one of the more conservative elements in the court, and we drew him. And so immediately we thought, oh my God, this is going to be an uphill battle. And it was amazing that we were able to achieve so much with a fairly conservative judge. I could just picture if we would have had one of the better draws in the District of Massachusetts, what we could have received as an outcome could have been incredible. But even what we received was amazing. So it just shows you how compelling the facts were, that even faced with, and not necessarily the most friendly audience, we were able to create quite a record and quite a triumph. The judge decided to do a modified approach, where even though he had provisionally certified the class and identified that there were overlapping claims and that they were similarly situated, he still wanted to make sure, this is where I think his background comes in, that's why I mentioned it, he still wanted to make sure he wasn't releasing anybody who would be a public safety or national security threat. And so he wanted briefings on each person. He wanted to know each person's personal, criminal, and other background. And he wanted it vetted by the court before they were released. So we were in a class action, essentially doing individual habeas, which was an immense amount of work, Because if you're going as a class, you should just be able to do it as a class. And we couldn't, because the judge was very concerned about the potential criticism of releasing somebody with a bad criminal record or who would be a danger to the community. And so that's why I explained a little bit about the judge's background, because I think it helps contextualize the process that we followed in federal court. And so we were kind of in this hybrid under the umbrella of a class action and class relief, but the judge was not going to just release people as cohorts or as a class. He was releasing people based on individual considerations. Interestingly, the considerations were never immigration related, right? Like it wasn't like, should this person, because they were all civil immigration detainees. And so from the judge's perspective, these people could have easily not been behind bars. They were in there because immigration opted to keep them in there. And that was also a very interesting strand in the case. Since the very beginning, the judge kept saying, feds, you have the discretion to release, and you should release, especially in light of the pandemic. And so it was very interesting that the judge tried to get the government to assert its own discretion, but the government refused. And so the judge started ordering the release of individuals, not necessarily taking into account their medical conditions or what their immigration circumstances were, whether it was compelling or not, but just a holistic assessment of who was before the judge, which was really interesting at a time when in most cases around the country, people were just talking about the elderly or COVID risk factors. Well, we included some of that in there, so the judge was sensitive to it. That was never the heart of the assessments. It was really a holistic assessment of each individual. I think with it almost felt, this was never expressly said or written, but it almost felt like the presumption was one of release, and that he was just making sure that there wasn't anybody who really shouldn't be released. So it was an interesting process, and it was one of these instances where you see that federal judges have a lot of latitude about how they organize a case and how they allow you to continue to prosecute the case. And so we ended up in a very hybrid world where we had been granted provisional class certification, but we were still doing individual briefings for each of the people at the facility, hundreds of people.
Professor, we have one more question back here, and then Professor Marcus, then we've got a question in the chat.
Well, mine wasn't really like a question. It was just kind of like an experience I just had about a month ago. I went to Nogales with the National Lawyers Guild, and it really broke my heart, in all honesty. I was just sitting there, and because I was a legal observer, and they were explaining to me, like, I don't know if anybody knows what the Nogales wall looks like. They put grades on it, and I have pictures of it too. I'm looking at it, with barbed wire around it to prevent people from hugging each other. So just like this whole, like racist kind of like, people who used to be able to hug each other now can't hug each other. And I marched with the asylum seekers on the side of Mexico. And I was actually trapped in Mexico. Like, people say, oh, you were trapped in Mexico. I wasn't afraid, but that they closed the border right there and then, because they're like, all these people are trying to get into this country. And I was sitting there and I talked to people, and they said, I'm just trying to find a safe place to live. Like, my family's being targeted by the cartels in Honduras and Guatemala. And I'm like, when people are making decisions, like, it breaks my heart. It feels like people are not seeing that these are humans who are just trying to make a better life for themselves, and not being like, people aren't taking accountability that from actions that happened in the 1970s and 1980s, like, this is still happening today as well. So I was just making a comment about that. I wasn't sure if you also met families and knew about like the asylum seekers as well, that like what was going on there.
Thank you for sharing. I appreciate that. Oh, please.
Yeah.
Yes, I apologize, I missed the last one.
So we have a comment with a question kind of at the end. One of our students went to Nogales as a legal observer with the National Lawyers Guild last month. And, really got to see the border wall with the grates and the barbed wire that was put in place to keep people from hugging, families used to be able to hug through the border, and they can't anymore. And she's just impacted by kind of this racist dynamic. And she was actually marching on the other side in Mexico, and got, quote unquote, trapped there because the border, as soon as people started marching, the border was immediately closed to prevent people from coming here. And she was just confronted with people who are just here to try to make a better life, being turned into a threat. And so she was wondering, have you met families in that situation, and kind of what your comments might be with respect to all of this.
Thank you for sharing, and especially because I know that having been there yesterday, it is heart-wrenching and heartbreaking to see the conditions that people are in, and unnecessarily. And so thank you for sharing that experience with us. And like you said, it's less of a question and more of an observation, which I appreciate. The conditions in Nogales are highly problematic. One immediate concern that I have is that it's just the disparities in how the entire process is working. The border is technically closed, and yet I walked through and came back perfectly fine without anybody asking me about my COVID status, without anybody requiring me to get COVID tested, without anybody asking whether I've been vaccinated. None of this was inquired about. I just presented my passport, walked through, came back like nothing had happened. And then you get to the other side of Nogales and you are clearly met with the reality that the border is closed, that people cannot come through. And so how does that coexist? You know, it's almost like a legal fiction, right? And earlier during my trip, I spent time in Mecca, California, where I visited the Galilee Center, which is a welcoming center on this side of the border. And at the Galilee Center, they are receiving Haitians, Brazilians, Russians, people from Asian countries and other places. So it is clear that people are still coming in. In the case of Mecca, people are coming in through ports in Yuma, in Mexicali, in San Isidro, near San Diego. So what is evident is that different border sectors have very different policies, and that those disparities are certainly affecting the way immigration is enforcing or not enforcing along the border. I was through connections made by, generously made by Professor Marcus, I've spent a lot of time with the Florence Project, which I have long admired from afar. And it was just fabulous to be able to go to Nogales with the Florence Project. And one of the things that one of the Florence Project attorneys said, you know, it is sheer luck. It is where you decide to cross, right? It is the mood of the Border Patrol officer who apprehends you, whether you get expelled immediately or whether you're brought in to a processing center, right? All of these contingencies that clearly show the lack of uniformity, the lack of clear guidance and application, and disparities in enforcement, because the way Mexican people are treated is very different from the way that people from countries further away are treated. And I'm sure some of that is just logistical in terms of being able to expel someone literally across the border back to Mexico versus getting someone on a plane and having to send them back to Russia or India. But the disparities still exist, and the due process concern still exists. And so what you're pointing to, I think, are real legal issues that are worth of exploration, and something that I hadn't fully appreciated until I saw it at work when I visited Mecca, when I visited Nogales, when I met people who had successfully come in at Mecca, and then met people who had been expelled in Nogales, and met families desperately trying to cross for the 7th time in Nogales, and how these things coexist, where a family is being welcomed to Mecca, a family is being rejected for the 7th time in Nogales, and families are constantly being deported, including with COVID. You know, all of these things are coexisting, and that is not coherent. That is not good policy. And most certainly, it is not following the appropriate due process principles that the Constitution provides. And so it raises a host of not just legal issues, but also practical considerations about the way we are enforcing immigration at the border in different sectors. And just the luck of the draw. I mean, how much of it is just luck is really, frankly, shocking that that's the way we are operating as the United States in 2021. Just sheer luck. Professor Marcus, you've had a question.
Come up and do it.
Please join me at the stage. This is your stage, Professor Marcus.
We are doing so well on time that I'm going to take some of that time to share with you some comments from a talk that I was watching right before this at the UCLA. They have an amazing center related to immigration policy, really focused on racism and immigration policy. So I want to share some of that connected to what you're talking about, and then ask you a couple questions. So, you know, one of the things at the beginning, I think Professor Silverman talked about, you know, it's the Biden administration. I don't know how you put it exactly, but why are we getting what we're getting? the Biden administration came in and said, or, before it came in, said, this is about the soul of America, and we're going to restore asylum. And then, when the Supreme Court says, well, you have to revitalize Remain in Mexico program because of the way you did it, instead of coming out the next day with a detailed memo about how they're going to undo it, they kind of say, oh, well, the court made us, and what can we do? And then at the same time, the atrocity of Title 42 and what a sham it is. So all these things are happening with the Biden administration, and it really, and at the same time, you mentioned some cases are settling. I'm interested in hearing what cases have settled that you've worked on, and I'm also interested in hearing. You said what we talked, because changes have included. We talked to some people. Who in the administration do you talk to, and who is the Biden administration listening to? Because just to make one other little tie-in, you mentioned that with your litigation, sometimes you have to be bold, despite what everybody's saying. And the administration is obviously being quite the opposite. Thinking that they're going to get more people along, that never worked for Obama or Bush or anybody. And Congress is not coming along. So what they're focused on in the UCLA talk was really executive action. And that's not really going so well, with one exception for TPS, for temporary protected status for Haitians. So I think I asked you like 3 questions there, but it should give me some stuff to talk about.
That makes a lot of sense, Professor. Thank you. And it dovetails nicely with some of the conversations we've had this week. Starting from the Biden changes. So a good example of a settlement is actually Savino, right? We started Savino. It was protracted litigation, and very intensive because we have to do these individual screenings and vettings. And shortly after the election, we started reaching out to the transition team, laying out our wish list. These are all the things we want, right? Shortly after the inauguration, we actually started settlement discussions with the administration. And so the posture going from, we're just going to duke it out in court until the end, but we were clearly winning. Let's just cut their losses short and let's just settle. I think that certainly was something that we would not have seen under Trump. Under Trump, we would have just duked it out, as we did. And so the Savino settlement is a good example of the administration identifying a sore eye and just saying we need to change course so that we could save face and get this, get these constant barrages of news articles saying, 10 more released from hellish conditions in Massachusetts, right? Like, it's just embarrassing. I'm a deep believer in connecting litigation to community advocacy, connecting it to communications and media strategy, because as I tell my team, if a tree falls in the forest and nobody hears it, it doesn't raise money, and it definitely doesn't make any policy changes. And so it's really important for us to match litigation work with communications, with community outreach and engagement. And so I think the administration really was concerned. And that's what got back to me in unofficial channels, is that they were concerned that it was embarrassing, that it was just headline after headline talking about miserable conditions in confinement centers, and that it was just embarrassing, and that it wanted to make it go away. And so I do feel that that creates a strong opening for us. We just this week, in anticipation of coming to Arizona, the timing was just quite right. We put together a complaint that we filed with the Office for Civil Rights and Civil Liberties, at the Department of Homeland Security and with the Inspector General on behalf of 48 Haitians who had been living under the bridge, kept under the bridge, and who had been released after public condemnation resulted in the federal government clearing the camp. They were a part of the group of thousands of people who had been under the camp. They came into the country. They were subsequently released after going through awful conditions, and then they arrived in Boston. Boston is the third largest Haitian American community in the country, believe it or not, after Miami and Brooklyn. And so we have a very large Haitian diaspora. So it was just a matter of time until those people from the bridge arrived in my neck of the woods. And as soon as they arrived, we connected with churches and community groups to interview the families. Within a matter of hours of them arriving in Boston, we had contact with 48 people, and we subsequently filed within a matter of days the complaint with Homeland Security for their experience. I sent the complaint to the officer for civil rights and civil liberties, who's somebody who I know from work over the past decade, a friend of mine, really, Catherine Cugiton, who is a terrific lawyer, brilliant strategist, and a tremendous asset to that office. As soon as she saw the email come through, within a matter of minutes, I had a response saying, complaint acknowledged, we will circle back with you soon, right? That is something that would have never happened under the Trump administration. It wouldn't have been somebody I knew on the other side, and it wouldn't have been somebody who would have taken the courtesy to say, thank you for submitting this. I see this is serious. We will get back to you shortly. Consider this the confirmation that we will be reviewing it, right? And so that's huge. That's a huge difference between the experience of what we would have had under the Trump era. And so I think that there are key folks all over the place. That's an example of Homeland Security. But in the Lawyers Committee network, Kristin Clark is now the head of civil rights at the Department of Justice, somebody who is deeply passionate about issues of justice and equity, and a big champion of these things before she went into the administration. And so we have really good people in the Biden administration. And I think it's a matter of strategizing about how to use them effectively, how to push them effectively in light of the other things we're talking about, the fact that the country is polarized, that they are under a lot of political pressure not to necessarily do what we're asking them to do, right? So to take a look at all of these different pressure points, trying to identify key opportunities for engagement, I think is important. And that means we have to sit down and really think through what our strategy is. What is the ask? How do we sell that ask to people who are our friends, but who are working within the confines of a political structure that is divided and that is feeling pressure from other interests, not just our interests? And so I think those are push-pull, right? There's a tug there, but I think there's also opportunity there. And so it's a matter of how do we capitalize on that while being conscious that we're never going to get 100% of what we want. And compromise is not a bad thing. It's not a bad thing. Despite what we might feel personally otherwise, it really isn't. A good settlement is a good victory. And so thinking through what we want, what's our wish list, but what are the things that we can live without is important. Defining what our needs are and what our wants are, those are different things. And I think if we can create a better articulation of what are things that we are willing to accept or not willing to accept, it could go a long way. And you get some surprising victories sometimes. If you would have said to me years ago that we would have shut down Bristol County, I would have said, you are on crack. It seemed impossible. And yet, because of the changes at the community level, at the political level, that confluence of things made it possible. And so I think it's important for us to take a look at those victories, kind of dissect them and really do a postmortem for what's working and what are ways that we could recreate that in other spheres. And to try to think through what are ways that we can engage the Biden administration that we just couldn't before under Trump. And that's actually why we decided to do the Civil Rights and Civil Liberties complaint, because we felt like under Trump, we constantly had to go into federal court, but there are more levers. Everything shouldn't just have to take a complaint and a lawsuit. And so if there are different levers that we could be pushing, federal court is always one of them. What are the other levers? And leaning into changes at the secretary level in these departments, I think is an important opening. And so we need to capitalize on that. And I might be wrong. Maybe I'm barking up the wrong tree, but then we course correct and then we file the lawsuit, right? So we need to cultivate multiple options, multiple bites at the apple. But I think capitalizing on some of the personal changes at the federal level is important, really important. In Boston, just to give an example of a different one of our strongest community allies, a community organizer, really, who used to be a domestic worker and then became very active in organizing domestic workers and other workers, was just appointed to a leadership position in a regional office of the Department of Labor. And so those type of appointments, I think, also create opportunities to think not just about what can I get from DC, but what can I get from regional offices that are in charge of our jurisdictions, that we could be doing investigations with, that we could be doing administrative complaints with in ways that simply were not viable under Trump. And so I encourage us to think, of course, of the traditional tools, right? We're lawyers, we can sue and we should sue, but think about what are the other levers that we have available to us, especially with the Trump administration changes. And I would say the other change that is important is ultimately that we need to be a lot more, we need to just drum up a lot more attention for these issues. Title 42 is something most American households have no clue about. It is not something you talk about over dinner around your dining room table. It just isn't. And we need to make it that issue. We need to make it that level of visibility. And so thinking about complementing legal strategies with ways to humanize the issue, to make it accessible and to change hearts and minds will go a long way, because the more people who are putting pressure on their congressmen or congresswomen, who are putting pressure on the administration saying, this is bad, we have to get rid of it, I think that political pressure is really important too. And so how we elevate the Title 42 issue, I think, is a very important thing here. And so those are just some thoughts about your question, Professor Marcus, which I really appreciate. Kate, should we go to the chat?
Yes, I was going to say we have a good question that will kind of tie this together, and then Professor Lee, I beat you by half a second. I have a question.
Oh, okay.
You get to pick.
Oh, I'm sorry. Maybe we should do Professor Lee. Yes. Professor Lee, you're right here, please.
Oh, well, I think the Zoom hand was up first. Was it not?
And let our speaker.
Okay, well, I can ask you a question. So I will let you pick. Do you want a comms question or do you want a Supreme Court question?
Whichever one you want to give me, Professor.
I don't know, actually. I'm going to ask you the other one after the session. Okay, perhaps I'll ask the comms question, because we have an ED here who I think thinks about comms a lot. So I've been surprised the extent to which we hear, even amongst our allies, that quote unquote the border is going to win us the election. And I just want to know, what messaging strategies would you suggest to counter violent such a, and I've been surprised and the sort of for both the individual and the fora in which I've heard sentiments lately, and it has caused me, really to want to have the best possible response to counter that kind of messaging, that kind of defeatist thinking. And I just, based on your experiences, both in the lawyers committee, what you've seen, or what would be your response to that sort of sentiment?
It's frustrating because I think that the question is,
I can-
please, yeah, sure.
Okay.
You should just stay up here with me, Kate, and like, hold
We
me
can-
accountable.
We can do that. I'm good at shouting too. So Professor Lee had a question, first kind of a comment about, she's surprised to the extent to which, we hear even among allies that the border is going to lose us this election. And she's wondering about possible strategies for countering this, being surprised even by individuals and fora in which we have heard this that have made her think of what potential strategies are. And so wondering kind of what your thought is about that.
I think it's just so easy to default to those type of really simplistic formulations. The border is going to lose us the election, or Afghanistan is going to lose us the election. When in reality, we have to realize that the political landscape is a lot more nuanced and complex than that. And ultimately, I think it's incumbent in the Biden administration to sell itself the work that it's doing and its impact on the ground. And so one thing that I think is critical is for the administration to take a lot more leadership in setting the tone for the immigration conversation. And I think the Afghan example is a good one, with the president doing multiple addresses about how this is just the way it is and the way we're going to move forward in Afghanistan, and setting the stage and setting the parameters for that conversation in very clear ways. We haven't seen that in other arenas. And so I think a lot of this comes from the administration, frankly, being in disarray when it comes to issues of immigration and not having that singular unified voice of how it's communicating on immigration issues. And then that allows a lot of different other voices to fill in the gap, to fill in that void, including highly, incendiary and divisive voices talking about the border. One thing that I learned just this week, for example, that I thought was so amazing, and maybe for you guys living here, you guys are exposed to this, but from Boston, I'm not, which is what makes this type of visit so important. I keep reading in the newspaper and hearing the news so much about how apprehensions are at an all-time high. But the number of apprehensions doesn't take into account people who are coming in, trying to come in for the 7th time, right? You've been expelled and then you get sent immediately back across to Nogales. Then you try to come back in the next day. That doesn't get recorded as like one person trying to come in multiple times. It just gets reported as one more apprehension, right? And so all of a sudden we have, the record high number of people at the border. How do we know that that's actually not just the same 1,000 people trying to come in again and again and again because the border's closed and they can't come in? And so for me, it's almost like when we look at these numbers that even federal agencies are feeding us, this is coming from DHS. We need to question, like, what is the basis for this information? Like, how are we quantifying apprehension and entry? How are we quantifying the number of people who are at the border? It made me realize after being in Nogales and talking to somebody who's tried to come in 7 times, like this person probably got counted 7 times. And I'm looking at statistics in Boston and having conversations with other advocates about, oh my God, record numbers at the border. It's one person trying to come in 7 times. And the fact that I didn't know that as an advocate, now imagine the average American. And yet what we're being fed from even from federal agencies is crisis at the border, record number of people. And so for your question, Professor, is a very good one about how we communicate and how we message the crisis at the border. And I think even the administration does not have a coherent way of presenting us as American people with a snapshot of what's happening and what is the way to fix it. And so that's why we keep going to these meetings and other, cocktail parties with people saying the border's going to lose the election. I'm actually not surprised when we have so much misinformation. It's out, and the issue of misinformation is, of course, don't even get me started on vaccine hesitancy, which is also connected to issues of misinformation, right? And so I think it's really important about transparency and how we're collecting data and how we're analyzing that data and presenting it to the American public. And the fact that even the White House has not been able to do this effectively leaves a lot to be desired. I keep thinking this election is Biden's to lose. And then that means that he needs to step up and win it. Another question from here?
So we want to keep on time, and we do have at least 3 more minutes. So I think we should try to get in that question that you.
And this, yeah. This is actually a good question to kind of circle around and end with, especially for those of us who are in civil procedure right now. This is from Benjamin. We're going back to the Sabino case, and he says, and I acknowledge that we've talked about a lot of kind of larger parts of the litigation, but this is going to boil us down to the very beginning. It says, please walk us through the stages of the litigation you pursued and the responses from the government, starting at the very beginning.
In 3 minutes.
Yeah, in 3 minutes. Professor Lorem, that is a packed question. I'll summarize it by saying that at every stage, the government said no, or the government objected. But it was fairly, in a summary, what I would say is we filed a complaint, and along with the complaint, the motion for class certification and for emergency relief. We actually appeared before the judge very quickly. It was within a matter of 48 hours. And it was in that initial conference that we started outlining the rest of the briefing schedule, and shortly thereafter we were doing the individual briefings. The judge that we drew is not just known for being conservative; he's also known for having a rocket docket, and so we went for motion practice very, very quickly. And the government, the government objected to the class certification, saying that there were no issues of commonality, which I think was absurd in light of the detention conditions and COVID. And the other thing the government objected to was the release of any individuals. The position that the government took is that the facility was able to provide adequate safety for the detainees, and that no single one of them needed to be released, essentially, is what the government said in a summary, which I actually think infuriated the judge to see that the government was taking such an extreme position. And that's when we started the briefings, which provided us with an opportunity to lay out each of the person's background, but also the government would present objections and would raise objections to the release of those people. And the government essentially objected to the release of almost every single one of the people, which was deeply frustrating to see that at one point the judge said the government isn't playing ball, because they really weren't. And it took a while for the government to really take the position that releases may be appropriate. But I think the important part there is, and I think this is a good point to end in, it really does take a village. At LCR, we had a group of 4 of us working on the case. Then there was a team of about I believe it was 8 law students from Yale Law School's immigration clinic, immigrant and workers' rights clinic. And then when we started doing the individual briefings because of the volume of work, we had pro bono support from Wilmer Hale, and they had a team of about 10 lawyers on the case. So it was a large case, and we needed to really marshal the resources, not just of my organization, but also of the clinic, of the private bar, to make it all happen. And I think that's a really wonderful example of how this type of work, it's not owned by LCR, it's not owned by the clinic, it's not owned by the firm, it belongs to all of us. And it's doing the work together in partnership and collaboration that gets the best outcomes. And that's a really great illustration of how public interest lawyering can build bridges between public interest and private practice, between legal spaces and community spaces, really thinking about how these community lawyering principles even work when we get a big law firm in the room, in the case, and how these things really can work together to produce optimal outcomes for our clients. And so that emphasis of collaboration and partnership is really critical. And my time is up, guys.
Oh, we went over a minute. Thank you so much for being here. Thank you so much for your incredible comments. And
Thank you.
yeah, thank you, everybody. Have a good day.